Welcome to this presentation being hosted by East Coast Environmental Law on environmental rights for the coast in New Brunswick. This is a project that's supported by a grant from the New Brunswick Law Foundation. I'd like to begin tonight with an acknowledgement, a land acknowledgement. So I'm coming to you tonight from Unama'ki, which is the traditional unceded and unsurrendered territory of the Mi'kmaq people. Unama'ki is also known as Cape Breton in Nova Scotia. And we have participants joining us from throughout New Brunswick. And so depending on where you live and work, you are on the traditional unceded and unsurrendered territories of the Mi'kmaq, the Wolastoq, and the Passamaquoddy. These are all territories that are covered by treaties of peace and friendship that were entered into with the British Crown beginning in the early 18th century. And I should acknowledge and note that I will be speaking tonight about Canadian laws, which are also settler and colonial laws. But we have to recognize that these are not the only laws that govern the coastal territories that I'll be chatting about tonight, and are also not the first laws that have governed these lands. So for many millennia, various Indigenous laws have applied to these coastal territories, and I think that we should make space for including those laws, giving them the recognition that they deserve. Just briefly about us, East Coast Environmental Law is an public interest environmental law charity based in Halifax. Our vision is a future in which laws and legal systems protect ecological health and promote environmental and climate justice throughout the Atlantic region. And so we work in all 4 of the Atlantic provinces, as well as in the federal sphere. We take a pretty dynamic approach to our environmental advocacy in the region, and we do this by engaging with individuals, groups, and communities, and working to try to make sure that environmental laws and policies are founded on responsible, transparent, inclusive, and proactive decision-making. So the agenda tonight is fairly simple. I'm going to talk for about 45 minutes about a couple of different coastal matters. I'll talk a little bit about government jurisdiction and the responsibilities in the coastal environment. I'll talk a little bit about the laws that shape coastal developments and activities and regulate them. I'll talk about aquaculture. I'll talk about land-based and marine-based pollution and the laws that govern those, as well as the laws that allow for coastal areas, species, and ecosystems to be protected and conserved. And I'll end just chatting briefly about some of the ways that folks can get involved and take action. And then we'll finish off the night with about 30 minutes or so for questions and discussion. So I guess we can begin with the question, so why the webinar? Why a presentation about coastal laws? What's so special about New Brunswick's coast versus other areas of the environment? And I'm sure that folks on this webinar tonight probably already have some kind of idea of or ideas around why coasts are so special and important in New Brunswick, but I thought we could just take a look at some of those reasons. So as a starting point, New Brunswick has over 5,500 kilometers of coastline that borders really important bodies of water, including the Gulf of St. Lawrence and the Bay of Fundy. And New Brunswick's coastal ecosystems have really important services and ecosystem functions that are really important both for humans and human developments and activities, but also for the species and for environment. For example, certain coastal ecosystems like salt marshes provide functions and protection against things like coastal erosion, coastal flooding, storm surges, and sea level rise that are actually being made worse by the climate change crisis. But they can also provide other functions such as sequestering blue carbon, which is when carbon is brought down into the root systems and the subsoil of salt marshes, and water filtration systems, and providing ecosystems and habitats for unique species. For example, this is a maritime ringlet, and the maritime ringlet is endemic to New Brunswick, which means it is only found in New Brunswick. And more specifically, this endangered species is only found in salt marshes in New Brunswick. So it's really important that we protect the coasts because they can provide really valuable habitat. So I'm going to get us started with some of the foundation of federal and provincial jurisdiction. And we begin kind of at the Canadian Constitution. And sections 91 and sections 92 actually set out some of the matters over which the federal and provincial governments have responsibilities. There are also matters that aren't listed in the Constitution. And in most cases, the federal and provincial governments share responsibilities, for example, in matters of environment. The federal government has responsibilities over matters including fisheries, shipping and navigation, as well as lawmaking powers over those activities or activities that are related to fisheries. So for example, wharves, public harbors, canals, regulating those with respect to fisheries and shipping and navigation. Federal government also has responsibilities over federal crown lands, and responsibilities over the land and water from the low water mark along the coast seaward all the way to 200 nautical miles out, which is the limit of the exclusive economic zone in Canada's jurisdiction under international law. And then New Brunswick has all kinds of responsibilities over local works, local undertakings, and other local matters, private property rights over natural resources, responsibilities and lawmaking powers over provincial crown lands, and generally powers to make laws over lands that begin at the low water mark and go to the land. And just an additional note, between the low water mark and the high water mark, all the way around New Brunswick's coast, that is generally considered provincial crown land. And we'll talk a little bit more about that. There are also other rights and responsibilities in the coast. I've already mentioned Indigenous laws in the land acknowledgement, and that can play a really important part in regulating and governing the coast. We can also have local government bylaws and rules and policies, and then there may also be private property rights and also corresponding responsibilities along the coast. I'm going to be focusing mostly on federal and provincial jurisdiction, but it is good to recognize that these other rights and responsibilities can exist, and you can actually find more information about these other rights and responsibilities in our summary series. So beginning with part 1 and coastal development. So there's no one law in New Brunswick or in Canada at the federal level, or really in any province, that deals entirely with just the coast. Often what you have is a number of different laws that have aspects or provisions that deal with coasts or that could deal with the coast. And coastal development and activities in New Brunswick are not just outright prohibited. They're often regulated, and there's really no spots along the coast that you cannot develop or conduct an activity, with some exceptions. I'm also not going to be covering federal impact assessment or provincial environmental impact assessment tonight, because we have an entirely separate recording and materials on those. But it's good to keep in mind that certain projects, for example, causeways, ports and harbors, and any projects that impact salt marshes that are 2 or more hectares in size will require provincial EIA, and some other large projects might require federal impact assessment. But putting that aside for a second, because it's just outside of the scope and the time that we have tonight. I'd also like to mention that there is a constitutional duty to consult. This is a constitutional duty that governments owe to Indigenous peoples. And they have to consult with Indigenous peoples before engaging in any kind of activity that would threaten constitutionally protected Aboriginal rights or treaty rights, as well as a corresponding duty to accommodate. So anytime a government is taking action and allowing a project or an activity proceed, that may trigger the duty to consult and accommodate. So there's all kinds of different federal laws that can pertain to the coast, coastal developments and activities that happen in the coast. Can't cover them all in 45 minutes, so I've just kind of focused on the key laws. There are a whole number that could potentially be relevant in each specific case, but we can't cover all of the laws in Canada. So the Federal Fisheries Act requires an approval if an activity or a project is going to cause the death of fish or is going to cause harmful alteration, disruption, or destruction of fish habitat. And these are sometimes called HADD, H-A-D-D. There is a Public Fisheries Act registry that has records related to fish and fish habitat protection and pollution prevention approvals. And so if you're ever interested in whether a project or activity has an approval, you can search that registry. The Navigable Waters Protection Act deals with projects when they might impair navigation or maritime transport. And there's really two kinds of projects that are set out in the Act. Minor works require public notice for certain activities, including erosion protection works or dredging. And major works require an approval in all circumstances. And those types of projects may include causeways and aquaculture operations. And these are works or projects that substantially interfere with navigation. And there are two separate regulations, the major works order and the minor works order, that you can look to actually see what all of the different projects are that meet one of those two definitions. There's also information about the authorizations that are granted under this act on a public registry, so you can go look at those and learn more. The Federal Species at Risk Act deals with threatened and endangered species. And anytime a project or an activity may impact one of the listed species, an approval or a permit will be required. And again, you can find more information about agreements and permits that have been issued for different projects that are impacting or may impact these listed species on the Species at Risk Public Registry. And finally, similar to the Species at Risk Act is the Migratory Birds Convention Act. And in this deals with any circumstances where a project or an activity will have an impact on a migratory bird. And there's a full list of migratory birds in the schedule in the Act. In cases where a project will impact a migratory bird, a permit is required. At the provincial level, there's a number of different laws that can also deal with coastal development. I've kind of chosen these three laws, but there are other laws that deal with, for instance, endangered and threatened species that can also be applicable. So under the Clean Environment Act, the release of a contaminant is prohibited into the environment. And so any kind of activity, including along the coast, that deals with release of a contaminant into the environment, which includes land covered by water, will require a permit. Under the Clean Water Act, under the Watercourse and Wetland Alteration Regulation, a permit is required anytime a watercourse or wetland is being altered. This is particularly relevant for salt marshes because salt marshes will always require a permit, and they're a really unique and important coastal environment. Now, I should note that in terms of watercourses, this permitting requirement would apply to things like lagoons and freshwater ponds that are located on the coast. But the definition of a watercourse actually doesn't include the ocean, so it may not be applicable to projects or activities that will alter the ocean or access or flow of the ocean in some way. And the Crown Lands and Forest Act is really important as well, because as I mentioned, that kind of strip of coast all the way along between the low water mark and the high water mark, it's generally provincial Crown land. And this act requires that a permit and lease be required for all projects on submerged Crown land. So that kind of strip would be a prime example of Crown land at the provincial level that would need permission. There's also some policies that are really important for coastal development in New Brunswick. And these are just some of the policies that are relevant. The Coastal Areas Protection Policy is really important because what it does is it creates two protection zones, a Zone A and Zone B. And within these zones, the activities and developments that are allowed are very restricted. So Zone A creates a protection zone between the high water mark and the low water mark. And activities in that area are very, very restricted. And that protection is extended to dune systems that are included as part of that natural ecosystem and those habitats. And then Zone B extends another 30 meters from the high water mark inland, and it provides another additional buffering zone, and certain activities aren't allowed. Additionally, under this policy, certain activities are not permitted at all below the high tide mark, which includes groins, breakwaters, and retaining walls. And this policy is largely implemented through that watercourse and wetland alteration permitting process. The New Brunswick Wetlands Conservation Policy is really important, again, especially for salt marshes, because the policy prohibits activities within the distance of 30 meters of any provincially significant wetland, and all coastal marshes in New Brunswick are considered provincially significant wetlands, as well as some estuaries. So in that case, the policy provides additional protection to those coastal features. The permitting wetlands and technical wetlands for watercourse alterations and wetland alterations also provide some additional guidance and help shape the permitting process for wetlands, and you can take a look at those as well. So moving on to the second part and thinking about land-based and marine-based pollution, which have really intense impacts on the marine environment, and thinking about some of the federal and provincial laws that deal with land-based and marine-based pollution. And when we think about these different types of pollution, a kind of rule of thumb that you can kind of help guide yourself with is that generally when pollution is marine-based, it's very likely to be within the sphere of federal law. And when it's land-based, it's very likely to be in the sphere of provincial jurisdiction, unless it's coming from federal crown lands in the province. And so we've already touched a little bit on the Fisheries Act, but the Fisheries Act is a really important federal law that deals with environmental protection and is really important for coastal protection. And specifically subsection 36(3), which prohibits everyone from depositing a deleterious substance into any water that's either frequented by fish or depositing that substance under any conditions where that substance will then enter water that are frequented by fish. And a deleterious substance can be any substance that if added to water, it would be deleterious to fish or fish habitat. And it can, in that case, it can be pretty much any substance. It can even be water if the water is heated up or really cold. It can also be a really toxic chemical. So the types of substances that can be a deleterious substance within the meaning of the Fisheries Act are really broad. Now, under the Fisheries Act, there are several regulations that actually grant exemptions for certain activities that otherwise would likely be releasing deleterious substances. And examples include pulp and paper effluent, wastewater systems, so for example, municipal wastewater systems, and aquaculture. And we'll get a little bit more into aquaculture in a moment. The Canadian Environmental Protection Act also deals with toxic substances and contaminants and is really important for marine-based pollution. And the Canadian Environmental Protection Act prohibits any person or a ship from depositing a substance into Canada's internal waters, the territorial sea, or the exclusive economic zone. So basically any coastal waters. And therefore, if you want to deposit a substance into any of those bodies of water, a permit is required. The Canada Shipping Act also is really important because it implements all kinds of international rules around shipping and specifically pollution prevention. So it deals with ballast water, garbage, gray water, oil and oily discharges, sewage. And there's all kinds of different rules and they're listed here. So for example, in the case of gray water, you can't release gray water from a vessel if it has a sheen or there are any solids. And you can't release sewage or untreated sewage within 3 nautical miles of the shoreline. So there are all kinds of important rules under the Canada Shipping Act. Now, in terms of provincial land-based pollution, I think the key law in this respect is the Clean Water Act, which prohibits the release of any contaminant or any kind of class of contaminants into water, including coastal water, in any of the circumstances that degrade the quality of the water, that endanger the health or safety of people or animals, that cause damage to private property or any property or plants, or that otherwise interfere with transport, businesses, or the use and enjoyment of coastal property. And again, a contaminant can be effectively any substance, but it includes pesticides and wastes. However, you can release a contaminant into water if you get permission. So as I said, I wanted to talk a little bit more about aquaculture. And aquaculture really involves the rearing of fish, shellfish, or marine plants, often in coastal or marine areas using open net pens or cages. So there are provincial and federal laws that deal with aquaculture in New Brunswick, the Federal Fisheries Act, and regulations made under that act, and then the Provincial Aquaculture Act. But there is some uncertainty and some collaboration involved in aquaculture, and I'll chat about that a little bit more. But so the relationship between the province and the federal government is actually managed under the Atlantic Memorandum of Understanding for the Development and Management of the Aquaculture Industry. And this MOU was signed early 2021 between all 4 Atlantic provinces. So Nova Scotia, New Brunswick, PEI, and New Brunswick. And it deals with some general collaborative matters regarding aquaculture and the federal government. So federally, the Fisheries Act is the primary law, and really it's the aquaculture activities regulations that apply to aquaculture. And so, as I had mentioned, generally there is a prohibition against the deposit of deleterious substances into waters frequented by fish, but the aquaculture regulations make it so that aquaculture operations aren't captured by the prohibition if the aquaculture operation has an aquaculture license, and that can be an aquaculture license provided either federally or by the provincial government, so in this case, New Brunswick, and the various conditions and rules around aquaculture operations that are set out in the regulations are adhered to and met. I should also note that Fisheries and Ocean Canada has proposed a federal aquaculture act, and that was a little while ago, but we really don't have any idea of when such an act might be required or created, or if it would even apply to New Brunswick. So, but that's just something to keep in mind for the future. In terms of the Provincial Aquaculture Act, this is the primary law that deals with aquaculture, and it sets out a licensing regime. It creates aquaculture standards, conditions for the release of medications and feeds, and deals with disease prevention and record keeping, as well as land designation, including licensing and leasing and permitting for provincial crown lands. And a lot of this stuff is captured in a regulation created under the Act. And so under the Aquaculture Act, no person in the province can carry out any aquaculture unless they have a license. And if the aquaculture is going to be done on provincial crown lands, an occupation permit or a lease will also be required. And generally, these leases and permits have terms and conditions. There is a requirement in the Aquaculture Act to establish a public registry for aquaculture, but as of the time of this presentation, no registry exists to that effect. There's also various provincial policies that can shape the direction of government decision-making around aquaculture that deal with different areas in the province or different species, for example, rainbow trout. And you can take a look at those policies if you're interested in specific aspects of aquaculture regulation. I've also mentioned the summary series already, and we have some more information about some of those policies in our summary series. And as I noted, there is some uncertainty with respect to jurisdiction over aquaculture. And that uncertainty comes from a court case that was heard before the British Columbia Supreme Court in 2009. And in that case, a number of applicants challenged the British Columbia government's laws around aquaculture that dealt with the same things we've been talking about, including fish feed and pest management and siting and licensing. And the lead applicant, Dr. Morton, made the argument that the provinces do not have the jurisdiction to legislate over the fisheries, because the Constitution is quite clear that the ability to regulate fisheries is exclusive jurisdiction of the federal government. And the province argued that it was aquaculture is in fact farming, which is within their power, and that they were not breaking any laws in terms of regulating aquaculture provincially. At the end of the day, the British Columbia Supreme Court did find that aquaculture was within the federal jurisdiction, and the provinces, or at least the province of British Columbia in that case, did not have jurisdiction to regulate aquaculture. And to this day, the federal government actually regulates aquaculture in British Columbia, but that is not the case in the Atlantic region. And so all of the Atlantic provinces outside of PI still regulate at the provincial level. Now, moving on to the next part, which is legally protected coastal areas. There's a number of different ways that coastal environments can be managed and conserved. And there's lots of different federal and provincial laws that can be used to protect coastal land, as well as the species that live in those environments. These can be land or ocean area protections, they can be species and habitat protections, and they can be other kinds of ecosystem conservation measures. At the federal level, there's really kind of two main ways to protect coastal areas. That is through marine protected areas under a number of different acts, as well as through national park designation. So you may be familiar with the term marine protected area, and a marine protected area is generally a term that's applied to any tool or legal protection that serves to protect and conserve marine space, marine environment. But under the Federal Oceans Act, a marine protected area is actually a specific tool and is defined as any part of internal waters, territory, sea, or the exclusive economic zone that's designated to conserve or protect species, their habitat, or biodiversity. So pretty broad objectives for creating marine protected areas. And marine protected areas under the Oceans Act take many years, often sometimes decades to create. And it really all begins with identifying an initial area of interest, or an AOI. And this planning process often involves stakeholders, government, the public, scientists, to identify areas that are really ecologically significant, that have really important species or habitat, or are really important for biodiversity, and that need to be conserved and protected. After an area is identified for potential designation as a marine protected area, there's lots of policy development. So things like, what are the objectives of the marine protected area? What kind of advisory committee will be created to manage the marine protected area? And so there's all these kind of considerations around what will the practical effect of this marine protected area be. The next step is actually drafting, creating regulations, and often regulations provide kind of a general prohibition against activities that would disturb, damage, destroy, or otherwise remove things from the marine protected area, as well as prohibiting things like dumping, discharge, or deposit of substances. And there is a federal minimum standards policy in regard to marine protected areas. And then, of course, once you have the regulation, then you have to continue monitoring and managing that marine protected area, which is done by government oversight and has input from advisory committees, often made from a wide group of practitioners, scientists, and others in the public sphere. There is only one Oceans Act MPA in New Brunswick, the Musquash Estuary MPA. And as you can see, it does have a massive coastal component to it. The next kind of way that you can create a protected area is through the Canada Wildlife Act, which allows the Canada Wildlife Service to protect and conserve habitat for wildlife by establishing national wildlife areas. And these national wildlife areas can include areas with marine components, and they can also include protected marine areas that are entirely offshore, entirely marine areas. There are none of those offshore of Newfoundland, but there are lots of national wildlife areas that have marine components. And the purpose of these areas is to preserve habitat for migratory birds and other species, with a kind of focus on endangered and threatened species. There are 3 coastal national wildlife areas in New Brunswick. And as you can see, they vary in terms of their size and location, and they can either be entirely coastal or have coastal components, and also have large water-based or marine-based components. There are also federal national marine conservation areas, which allows Parks Canada, which is an agency of Environment and Climate Change Canada, to protect and conserve marine heritage and natural heritage, and to provide opportunities to educate the public about those ecosystems, about those environments, as well as to create opportunities for them to enjoy those spaces. However, there's no currently existing or planned national marine conservation areas for New Brunswick. And I also mentioned national parks. The Canada National Parks Act does allow for the establishment of national parks or park reserves, which are meant to protect habitat. And in national parks, there's often really tight restrictions or prohibitions on the use or occupancy of those lands. And often a permit or other approval needs to be granted, usually for things like recreation and scientific study. However, I will note that Indigenous persons may carry on harvesting of traditional renewable resources in any national park reserve. And there are 2 national parks in New Brunswick, and both of them have a pretty significant coastal component. In terms of New Brunswick protected areas for the coast, there's really kind of 3 mechanisms, and they include provincial parks, protected natural areas, and wildlife refuges. So the Protected Natural Areas Act allows for designation of protected natural areas, and these are really meant to protect biological diversity as a network within the province. And there's kind of 2 classes of protected natural areas. Class 1 essentially prohibits activities or people from entering into those areas, whereas Class 2 areas are still really restricted, but they do allow some activity. And a permit is required before activities can occur in a protected natural area. So there's several protected natural areas in New Brunswick that are located along the coast, including 2 Class 1 and 4 Class 2 protected natural areas. And you can learn a little bit more about these in our summary series. The second way to protect areas of the coast is through the province's Parks Act, which allows for the creation of provincial parks, which are really set aside for the use of by present and future generations, and where lots of activities like mining and quarrying and hunting are usually prohibited, and other things like damaging those parks is also prohibited. Provincial parks also provide some potential for shoreline areas to be given some protection because the Act prohibits the removal of sand or gravel from provincial parks. And the prohibition against mining and quarrying is also important because things like peat from coastal marshes is also prohibited in terms of excavation. And finally, the Provincial Fish and Wildlife Act allows for the creation of wildlife refuges and management areas. And within these areas, there's certain activities like hunting, trapping, and snaring that are prohibited except with authorization. Now, the Fish and Wildlife Act is really geared to and governs wildlife generally, so it's not the greatest protection you might see, but you can learn a little bit more about the areas that are listed for protection in the schedules of the Wildlife Refuges and Wildlife Management Areas regulation. And I will note that the protection provided by these areas does extend to lands that are covered by water. And so that means that things like, or areas like tidal marshes, foreshore flats, and bays and coves could receive protection under this act. And finally, getting kind of to the last part of this presentation, I just want to talk a little bit about the general types of things that can be done to take action to conserve and protect the coastal environment. And these include gathering information and participating, reporting activities to appropriate authorities, and even taking legal or non-legal action. So gathering information is really the first key step. And this is relevant both to if you're a person who's interested in developing some area of the coast in a responsible manner or sustainable manner, or you're concerned about an activity or development in the coast or along the coast. So when you gather information, you should think about what kinds of laws might apply and what level or levels of government would be responsible. So some of the questions you might ask yourself are, is the area above or below the high water mark, or the low water mark? If an area is above the high water mark, it's more likely that it's provincial jurisdiction, provincial crown land. And if it's below the low water mark, then it's very likely going to be federal jurisdiction and federal law that applies. You might want to think about the types of species or habitats in the area, and thinking about these in regard to species at risk or migratory birds or other protections for specific species or habitats. Does the project impact fish? Because if the project impacts fish or fish habitat, it's very likely going to be protected under the Fisheries Act, and there's definitely going to be a component of the Fisheries Act and Fisheries Act protections, in most cases dealing with kind of coastal developments and activities. You can also think about marine and land-based pollution and think about the source. Is the pollution coming from a ship? Is there debris on the water? Is there sewage on the water? Or is there debris coming from a land source? And if so, is it federal crown land, provincial crown land, or is it private property? Now, in the case of private property, provincial jurisdiction will apply. And then you can also think about, is there information about permits or approvals that are listed somewhere on a public registry? And I noted several times tonight, specifically with regard to some of the federal laws, that there are in fact various public registries where you can find out more information about whether a project has gotten a permit, what are the conditions of the permit, what are the approvals for, what are the terms and conditions and limits to those approvals and permissions. And you can also think about what are the rights and responsibilities in the coastal area more generally. So again, thinking about what laws might apply and what responsibilities do folks have. Once you gather that information and you're still concerned about an issue or think that someone is breaking the law, then you can think about asking yourself, well, what provincial or federal agency or department might be responsible? Who is the responsible authority? And you can report that to them. You can also think about whether there are reporting mechanisms within the relevant law and regulation. And there are some laws that have specific provisions around investigations that may be applicable. And so it's always a good idea to get a sense of which law might apply and is there a specific mechanism built into that law. And finally, you might also want to consider taking legal action. And there's various kinds of legal action that can be taken. And obviously this is not the place and time to speak about all of these in any kind of depth, but just to give you a general sense, you can take private action. So as an individual, you can take action against a government or another individual or an organization or a company in a private lawsuit. And examples of causes of action that might govern a private action include a nuisance, negligence, trespass. So these are kinds of things that, if you're really interested, it's always a good idea to speak with a lawyer to learn more about these possible avenues. There may be a statutory right of appeal in terms of certain decision-making processes, and those are often set out in specific statutes, laws, or regulation. And then you might also think about a judicial review, which is when you ask a court to consider whether a decision that was made by a government or a government decision maker, like a minister, was fair, was reasonable, and was lawful. And if the court finds that a decision was not fair, reasonable, or lawful, then the court may refer that decision back to the decision maker or make another kind of order to require certain things to be done. You might also think about taking action that's non-legal. So thinking about entering into dialogue, thinking about public advocacy and media advocacy, or taking opportunities like mediation and restorative justice avenues to try to resolve those conflicts without resorting to legal action. And there's lots of ways that things can be resolved without going to court. So that is the end of my presentation. We're going to take a look at the questions here in a moment, but I would like to remind everyone again to really check out our environmental laws for the coast in New Brunswick volume of our summary series, because there's lots of additional information